In the tort of negligence, the liability is premised upon fault. It must be shown that the defendant were in the breach of their duty to take reasonable care of the claimant, and because of which claimant suffered a damage. The onus of the proof lies on the claimant. The first claim which Rosa can bring is against State Gallery and the other churches. Rosa was exposed to radium in her workplace, and because of which she contracted with lung cancer. The actionable damage in this case is personal injury. It is established in the case of Wilson and Clyde Co. Limited that employers have a common law duty to take reasonable care or to take all practicable measures to prevent inhalation of any harmful substance by the employee or other persons present at the site of the work. Such duty is also supplemented by the provisions of Section 2 and Section 3 of Health and Safety at Work Act 1974. The defendant is judged against a minimum degree of care and skill known as the standard of care, and if they fell below this standard, they are in the breach of the duty. Whether the defendant is in a breach of duty is looked in the light of a cluster of considerations by the court. For example, it was established in the case of Brown and Rolls-Royce that in industrial sphere, the court may attach relevance to the existence of a common precautionary practice throughout the industry against injury. The question posed by the court is what level of care and skill was required by the activity which the defendant was pursuing. The other three factors considered by the court to measure the standard of care is: number one, gravity of potential harm. The reasonable man must consider the probability of injury occurring and the gravity of the consequences of injury by the activity they are pursuing. And the authority for this factor is Paris and Stephanie Borough Council. Number two, cost of precautions. A reasonable man must consider the precaution for preventing the injury while pursuing the activity. And in the case of Latimer and AEC Limited, it was held that the House of Lords will look the precautions in the light of the cost that may incur in providing those precautions. Number three, social utility. The court will then assess the social utility of the activity undertaken by the defendant. It is evident from the case of Bolton and Stone that higher the social utility of the activity, the lower the courts are inclined in finding it a breach of duty. It can be said that it was foreseeable by both the defendants that an exposure of radium is dangerous and can lead to lung cancer. However, the facts of the given question are vague to reach an absolute conclusion on the breach of duty. Therefore, assuming the breach, I shall move on to build a causal link between the breach of duty and the injury sustained. The standard rule of causation is that it must be proved on balance of probability that but for the defendant's conduct, the damage would not have happened. In the case where the claimant on application of but for a test cannot establish liability due to the lack of enough evidence, causation can still be established if it is proved that the defendant materially increased the risk of disease. In the case of Fairchild and Glenhaven Funeral Services, the disease was indivisible, meaning it cannot be determined if the disease was contracted from a cumulative exposure or by a single exposure, therefore making it impossible for the claimant to prove under which employer's employment the disease was contracted. Lord Bingham formulated a scenario in which the Fairchild case would be applicable. If, number one, the claimant was employed at different times and for differing periods by more than one employer. Number two, these employers were subject to a duty to take reasonable care to prevent the claimant from inhaling any harmful substance. Number three, they were in breach of their duty. Number four, claimant suffers a fatal disease resulting from the inhalation. Number five, any other causes of claimant's disease can effectively be discounted. And number six, but claimant cannot prove on balance of probability that which employer was responsible for the disease. In such a case, the claimant will be entitled to recover against each of the employer by showing that each of them have materially contributed to the risk of injury. It is accepted by the medical community that exposure to radium increases the chance of developing lung cancer. However, it is unknown whether the cancer develops because of the cumulative exposure over a period of time or whether a single exposure is all that is needed. This case falls under the Fairchild exception, and once the breach of duty is established by the defendant, the causal requirement is satisfied by the fact that each defendant's wrongdoing materially increased the risk of contracting the disease. Now, another argument can be taken about the level of exposure and if the level of exposure was tortious or non-tortious. Applying Barker and Chorus, in which it was held that it is irrelevant whether all other exposure of RTM was tortious or non-tortious or was caused by natural causes or by the claimant herself. These distinctions can be relevant to whether and to whom responsibility can also be attributed, but not to establish the causal link between the defendant's conduct and the claimant's injury. Following Barker, the attribution of liability will be on proportionate basis according to the time for which Rosa worked with each employer. Any element of contributory negligence during the period of exposure for which the defendant was responsible will go on to reduce the damage paid by the defendant. Here, Rosa also used RTM on some of her personal projects. This would establish contributory negligence. Nevertheless, Rosa has a strong claim here. The second claim lies between Rosa and Mr. Khan. Mr. Khan diagnosed her with asthma, and 3 years later, Rosa attended a new specialist who informed her that she has a rare form of lung cancer. At this stage, Rosa was told that she only have a 10% chance of survival. If Mr. Khan would have diagnosed her correctly, her chances of survival would have been in the bracket of 45 to 55%. Rosa may bring a claim of consequent loss of expectations of life due to the delay in treatment resulting from the misdiagnosis. Mr. Khan owed a duty to take reasonable care while diagnosing her. In Bolam and Frine Hospital Management Committee case, Judge McNair said that the standard of care that should be exercised by the doctors is that of an ordinary skilled man exercising and professing to have that special skill, and it would be based on the common medical practice and the reasonability of existence of such medical practice. Clearly, misdiagnosis by Mr. Khan was a breach of his duty. The facts of the present case is analogous to the facts of the case called Gregg and Scott, in which the claimant had a 45% chance of recovery, but due to the misdiagnosis, the claimant's chances of survival was reduced to 25%. The claim was unsuccessful in this case, as the adverse outcome, meaning the death, had not yet occurred, and almost any claim for loss of an outcome could be formulated as a claim of loss of chance of that outcome, and courts do not want that. And also they said to adopt possible causation rather than probable causation as a criteria of liability would be a radical change, and it should be left with Parliament. Therefore, applying Gregg, Rosa has a weak claim in loss of chance, but applying Williams and Bermuda Hospitals Board, in the cases of this case is applied in the cases of indivisible injury, and a claim can be brought by Rosa against Mr. Khan stating that his negligence has materially contributed to her injury. In Williams, it was held that the hospital's negligence contributed to sepsis, which in turn caused the injury. It then followed that the hospital's negligence had contributed to those injuries, had materially contributed to those injuries. It can be said that because of Mr. Khan's negligent diagnosis, lung cancer was developed. Therefore, a claim in material contribution towards the injury can be brought by Rosa against Mr. Khan. Thank you.